utmost convenience. We have a friendly office and provide all the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society Accreditation House to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. We of solicitors are here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello everyone, good afternoon. Welcome to Heritage TV, hanging out with Vicky. I must apologize for the slight late start for the show due to some technicalities, but we thank God everything is up and going. Today we'll be discussing the topic, the good character requirement, applying for naturalization as a British citizen. This program, as usual, as you know, is being sponsored by BWF Solicitors, Victon Estates. Let me welcome our resource person, Lawyer Eunice Achampo. Hello, Lawyer Eunice.
Hi, Vicky. How are you?
Lawyer Eunice, can you hear me?
Yes, I can. Can you hear me?
Good. How are you doing? You are welcome to hanging out with Vicky.
Thank you. How has your week been?
Yes, everything has been good.
Oh,
as usual, always looking forward to Saturday for the Legal Hour show.
Oh, yes. And I think this week has quickly gone by because I feel like we were just doing the program just a few days ago and now we're back here again.
Right, Laura Eunice. We have to do our job. So, like you said, the week is gone so quick. Yeah. And by the time you realize we are, end of June.
Yeah.
Heading towards July. So, Laura Eunice, quickly, before we, start talking about this topic, do you have any updates for us?
Yes. So, as you mentioned, we're really nearing the end of the month. By next week, we would have been, a few days, should I say, into getting into July. So, I think that as many people as possible who are EU nationals, are family members of EU nationals, are family members who have retained their rights, and those that, for instance, have derivative rights, or even have residence card, or even the permanent residence card, will all have had to do the EU settlement scheme. And for those that may not be, should I say, electronically savvy, by God's grace, the Home Office has now come up with a paper application form for those who may not be able to make the application online. So if you are not electronically savvy and you think that the paper application will be the best way forward to make the application, then of course do make the paper application. And with the paper application as well, they would instruct you when to go and have the biometrics taken. So you are not the one having to book a biometric appointment. They will instead send you a letter to go and have your biometrics taken. So that's one of the positive things about the paper application that they have now got. So I think as many people who can, of course, this is the EUSS paper form on their website. So as many people as possible who cannot make the application on the online application form they have on their website can now do it on the paper form. So that is also one way of getting around this whole thing. And of course, you have to post the documents to the address before the 30th of June 2021. So as many people as possible who are not able to complete the form electronically can now complete the paper form, which is the EUSS paper application on their website, and it's also free as well. So yes, that's a bit of an update that I wanted to put out there.
Okay, all right. Thank you for the info. Ladies and gentlemen, let me also remind everyone watching us who is joined in, please share to all your contacts. Let them join in this discussion. I also love to hear from you. As usual, when you send in your comments, it makes the program more interesting. So please do send in your questions through our Facebook portals, BWF Solicitors and Heritage TV Facebook page. And myself and Lawyer Eunice will be able to pick those questions up, and Lawyer Eunice will do justice to the questions as she always does. So Lawyer Eunice, with today's topic, why is it applying for naturalization as a British citizen? The good character requirement is very, 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 very important. Why is that?
Okay, so as many of us who may have British citizenship or may not have British citizenship, all of us know that there has to be an application if you're not naturally a British citizen because your parents were settled or British before you became British. You would have to apply to either register or to naturalize as a British citizen if you're a third country national. And so some of the requirements include the fact that the person has to be of full age, and full age basically means that the person is 18 years old and above. And that, of course, they have to be of capacity. So that means that they have to be sound-minded. So they don't have any, shall I say, mental illness, which will cause them to not even understand the application that they are making. And when you look at Section 6 of our British Nationality Act 1981, it also states that they must meet the requirements under Schedule 1 of the Act. And under Schedule 1, the first requirement there is the fact that the person must be of good character. So you don't necessarily have a definition within the Act of who a person who is of good character is, but you have what it is not. So rather than looking at it from that positive angle of who somebody is of good character, they look at it from the point of view of they are looking at it from the person who is not a person of good character. So when you look at the Home Office's guidance, for instance, in terms of the good character requirement, it has a list of factors that it looks at in terms of somebody who is not of good character. So the first thing that comes up is the person's criminality. So if they have any criminal convictions, if they have any cautions, reprimands, or warnings, if they have non-custodial sentences, which means that they have not been given prisonable sentences. So maybe they've been given a fine, or maybe they've been given some communal punishment or something of that sort. All of those come under a person's criminality, or if, for instance, they've given that person a deportation order or excluded that person from the United Kingdom. Those things are things that will come under a person's criminality. And then they look at things like the fact that somebody may have financial soundness. So if we say somebody is financially sound, under their guidance, they're trying to say that that person is not somebody who has been declared bankrupt, or whose company has not gone into liquidation, or somebody who has decided to not pay their NHS debts, or somebody who has fraudulently decided to take public benefits when they know clearly that they are not entitled to those public benefits. And then somebody who, for instance, is not paying their council tax. That also comes under somebody who is financially unsound. And then it has things like international crimes that people may have committed, terrorism, and behaviors that may not be conducive to the public good is also one of the other factors that they look at when looking at somebody who is of good character. And then they also have notoriety. So somebody who may be notorious for being, let's say, somebody who is part of a gang. So everybody knows them for being part of maybe a gang, and so they are notorious in that way, and that will also be something that they will consider if they were looking at an application for naturalization for that person. And then another factor that they also look at is the fact that maybe that person may have used deception, or they may have been dishonest in previous applications before this application for naturalization. They will also look at the fact that they may have used false information or false documentation in such applications as well. And they also look at certain immigration matters. So if, for instance, you have come into this country as an illegal entrant, or you have come and you've overstayed your permission, or you have come and your conditions do not allow you to work, because most visit visas, for instance, don't allow you to work or to study and to do most things. And if you've broken some of these immigration conditions, all of these can affect the good character requirements that they are looking at. And then you also may have somebody who may have been granted British citizenship before, and then deprived of that citizenship because they were found to have committed a criminal offense, or they may have deceived the Home Office when they were being granted British citizenship. And so in one way or the other, they have been deprived of that citizenship under Section 42 or 43 of our British Nationality Act. And so these are different factors that the Home Office may consider when they are looking at whether a person is of good character or not. And there will be instances where they will say, no, we will never give this person British citizenship. And that is in extreme circumstances where, for instance, a person may have committed terrorist acts, or a person may have assisted somebody in carrying out a sham marriage, for instance, and cases where they believe that this person has consistently and is continuously being a person who is of bad behavior. So they it's not just one offense, but they are a persistent offender, and they may look to say that, you know what, there is no way that we can grant this person British citizenship. But in all these factors that I've mentioned, most of the time, the word that is used is may not be granted. So there is the likelihood that they can assess and look at positive, should I say, mitigating circumstances. And then, of course, if the need arises that they grant this person British citizenship, they will go ahead to do so. So it is one of the most important things, because obviously they want to make sure that they are allowing people who would benefit society in general and also benefit the economy in general to be part or to be privileged enough. Because when you look at Section 6, it says that if the Secretary of State thinks fit, so if she believes that you are fit enough to be entitled to this citizenship, then she may go ahead and grant you. So it is a discretion. It is not something that I will call an obligation on the Secretary of State. So having British citizenship is a privilege to that person who is applying for it. And so you have to make sure that as much as possible, you can show that you are somebody who they can see is of good character, and they believe that you will be a good addition or beneficiary, and also somebody who also benefits society in general.
Oh, okay. All right. So, Lawyer Eunice, when does a person usually naturalize as a British citizen?
So usually it will be if a person has reached the age of 18. And most of the time, of course, when you're saying that somebody has reached the age of 18, maybe at that time they may not be able to meet the requirements. So just because this person has reached the age of 18 doesn't necessarily mean that they can just go ahead and naturalize. They will also have to meet the other requirements to be able to make the application to naturalize as a British citizen. So in the beginning, I was saying that, of course, they would have to show that they are mentally sound, and also the fact that they have good character, and also the fact that they should have had indefinite leave or no restrictions to their leave in the 12 months before making their application. So usually you should show that in the 12 months before your application was made, you had indefinite leave to remain. And if you look at Section 6, it's divided into two parts. So there, for those that are for married couples and those that are not married couples. So usually if you are a married person and your application is being done for naturalization, they will consider the fact that your spouse is settled or British, and that you are making the application right after you've gotten your indefinite leave to remain. So you don't have to wait that 12-month period for them to say that they are granting you naturalization. But if you are somebody who is not married to somebody who is settled or British, then of course you would have to be able to show that 12-month period before making the application for naturalization. And then of course, you have to show that in that 5-year period before the application was being made, that you have lived in the UK legally. And so at that 5-year period, at any point in time, you shouldn't have broken any immigration laws, or you shouldn't have been in breach of any immigration conditions, or any immigration, should I say, requirements that were put on your stay or your leave. So you should be able to show that as much as possible you have lived here soundly, legally, for that 5-year period before making the application. And also that you have lived in that in this country, which is the UK, and you have not been absent for a period of 450 days. So usually when you look at 450 days over a 5-year period, that's almost like 18 months. And so you shouldn't have been absent for that period of time within that 5 years. And then for the 12 months before you make the application as well, you should be able to show that you have not been absent from the country for a period of 90 days. And so 90 days is roughly about 3 months, not exactly 3 months, but about 3 months. So you should be able to show that you haven't been absent for that period, because this is just to show them that, of course, you are looking at the UK as your main home, your principal home, and it's not just a place where you come and go as and when you want. And the fact that you have decided to make the UK your main home, they want you to be conversant with the language. And so they have the English language test, which most people have to complete at a level B1. Or if you already have a degree from a UK-based university, then of course you don't have to do that English language test. Or if you are from an English-speaking country, which is about 18 different countries on the .gov.uk's website, and most African countries are not on that list. So if you are not on that list, then it means that you definitely have to do the English language test, or you should have a degree that meets that specific level B1 required framework level. And of course, if you are able to meet the English language requirement, then you can go ahead and do the Life in the UK test. So the Life in the UK test is one of the other requirements that people would need to meet in terms of getting that naturalization done. So if you have completed or you have done all of these things and you think that you are able to now make the application for naturalization, they would then assess the evidence that you've put forward to them and grant you British citizenship. So yes, when a person has reached that full age and is able to show that they are sound-minded, and then they can meet the other requirements that I've just mentioned, they can go ahead and naturalize as a British citizen.
Okay, great. Now, Eunice, you know those factors you raised that if you go against those rules, such as owing the NHS, you have a criminal conviction. These few points that you raised. At what points can these factors be overlooked? So let's say one applies and these points flags up, and due to that, you are unsuccessful with the application. Now, is it the end of the road for such a person? Because bear in mind, I believe that probably there was a certain situation that led to these things happening. So if the applicant wants to rectify it or wants to show remorse that even though I went into prison or whatever, I've turned a new leaf. I haven't had any issue with the law. Also, regards to you owing the NHS, things like that, and you make arrangements to have them paid. Is there any way you could be given the chance to reapply?
Of course. So like I was saying at the beginning, it's not a blanket no forever. Whenever you come and apply, we will always refuse. Obviously, there will be some discretion applied in terms of these different factors. So for instance, somebody has committed a criminal offense and they were in prison for, let's say, 6 months or 12 months, and they are making this application for naturalization. Usually they will consider factors. For instance, was this person a young person when they were committing this offense? How long ago was this offense committed? Is this an isolated conviction? Have they shown remorse? Have they shown that there are circumstances in their life that show that they have been of good character since then. They will look at different factors surrounding the whole issue. Unless you are saying that you currently have a pending criminal case and you are going to be convicted, and so you are trying to make the application for naturalization before your conviction. Unfortunately, in that case, they would say no. They would tell you they will wait for the outcome of the court decision before they make a decision on your naturalization application. So unfortunately, you can't use that as a way of bypassing their good character requirements. So there are so many factors that they will consider. And in a case like somebody who was convicted of an offense a while back, and they have obviously shown remorse over a period of time, usually they would give that person 10 years from the time they were convicted of that offense. And if the 10 years has passed, then of course they can make the application and show the mitigating circumstances that, of course, it was a long time ago and they have shown remorse. Maybe they now have a family. Maybe they are doing things in the community, like supporting other youths who were in the same position as them. You can show so many different ways of how you are now somebody who is a person of good character. And so it helps to show that maybe you're volunteering now, maybe you have a family, you have children that look up to you, and the rest of it. And usually in cases like that, of course, they will grant if they do see that you have changed or you have become somebody who is now showing good character. In cases where, for instance, you have non-custodial sentences, so sentences where you were not sentenced to prison. So, for instance, you were given a fine or you were given some sort of community order or something. Usually, they would say that the application may be refused if 3 years have not passed since that order was given. And so, usually, if you are saying to them that, of course, the offense was maybe you driving and you were overspeeding, and therefore you've been given some penalty points and you've been fined as well. Of course, they are looking to see that this is not somebody who is persistently committing such offenses. You know, some people do it as often as anything. And if you are somebody who is probably often speeding and getting penalty points, then they will just refuse it because they think that you are somebody who is persistently showing that behavior. And so, of course, the 3 years will have to pass from the time that you receive that fine or notice to be able to make the application for naturalization. And then you have cases where, for instance, you were saying that somebody owes the NHS. Even with immigration applications, they would usually say that if you have an amount which is about £500 or more that you owe the NHS under the suitability requirements, this may cause them to refuse the application. But if you have made some arrangements to pay for that, should I say, amount of money that you owe to the NHS, then of course they will look on that favorably. And in terms of naturalization, they want to show that you have cleared those debts. So unfortunately, if you are still owing, it will not be easy to make the application because they have clearly stated in their guidance that you should be able to show that you've cleared your debts with the NHS before they go ahead to look at your application favorably. So unfortunately, it is not just making the arrangement to pay the debt off, but it is also showing them that you've cleared those debts as well. So different factors require different, should I say, periods of them granting or not granting you citizenship. And like I said, there are factors that they would look at in terms of your mitigating circumstances when, for instance, you've committed a criminal offense and they believe that you have now become a person who is of good character, and therefore, for instance, if you were somebody who was very young and you committed the offense a long time ago, they may look at it in an exceptional circumstance and grant you naturalization in that instance.
Okay. Yes, ladies and gentlemen, if you just joined us, we are discussing the good character requirement, applying for naturalization as a British citizen. And with me is Mrs. Lawyer Eunice Achampong, solicitor from BWF Solicitors, who is taking us through the step-by-step procedure for applying for naturalization as a British citizen. The good character requirement, which is being discussed. Please send in your questions on all our social media handles, especially Facebook, where we are live. On BWF Solicitors Facebook page, you can send in your questions. And also on Heritage TV Facebook page, you can send in your questions. This is your host, Vicky Newton. Laura Eunice, I've got a question coming. Kemi is saying that about 2 years ago, I tried to make an application to naturalize as a British citizen, and my application was refused. This was because it was stated that I had some NHS debts that had not been cleared. When will it be possible for me to apply again? I think we've just
touched on that. Yeah, so as I was saying, definitely it has to be cleared. So she can reapply once it has cleared. So if, for instance, she's left with £2,000 to pay off, then of course she needs to pay off that £2,000, and then she can reapply for naturalization again. So of course, those are some of the factors that they look at. It would have been easier if they said, if you have made arrangements to pay off the debt, then we may consider granting, but they would usually say that they want the debt to be cleared before they go ahead to grant that person naturalization.
Right. So, Lioness, how about those who've got CCJs, have taken loans which they didn't make an attempt to pay them off? When it comes to CCJs as well, is it just one CCJs will be considered, or if you have more than one CCJs, how does it work when you look at that aspect? Going for loans and not paying them back, and also having CCJs on your credit score or credit profile, if I should say.
Yeah, so when I was talking about financial soundness, it included obviously things like not being bankrupt or not going into liquidation, but also the fact that you may have certain debts. And so when it comes to civil orders, so for instance, you were just mentioning county court judgment. When it comes to judgments like that, and of course, you know that an order has been given by the court to make a certain payment, and you have disregarded it. When you look at the policy in terms of civil court orders, they would say that, of course, the person may not be refused unless they are showing complete disregard for the court order and have not made any attempts whatsoever to obviously follow through with the court order. So if, for instance, you've got a county court judgment against you and you've decided you're just going to completely disregard it, you are not going to really do anything about it, then of course, you are just digging a hole up for yourself. So it's important that as much as possible, you start to do something about it. I don't think anybody likes to have a bad credit score or anybody wants
Exactly.
that on their records for a long period of time. So usually when that happens, I know that most able people would do something about it rather than just let it lie low on their record, because at the end of the day,
Yeah.
if it is continuous, it affects other things as well. And it's not just that county court judgment. If you want to go for a mortgage and the rest of it, it will just affect all those other things as well. So it's important that you obviously do something about it. Otherwise, in cases like that, they may refuse your application, and especially if it's persistent. So where that offense is being done over and over again, then it means that you are showing a complete disregard for the law, and therefore they will refuse your application for naturalization. So all of those things, they have their discretion. They may not refuse it, but if they see that this person is showing complete disregard or is not making any attempts whatsoever to make any amends, then of course they will go ahead and refuse. And if it's something that is being done persistently, then they will also go ahead and refuse the application. Yeah.
Okay. Right. I've got a next question. This person doesn't want to be named. I think it's in connection to CCJ as well. I'm completing an application for naturalization. I've got a question about criminal records. Please, I have county court judgment, CCJ, which I wasn't aware. I happen to have found out on Claire's Core Credit Search. Is it going to affect my application? If yes, what is the way forward, please?
Okay, so of course, this is somebody who has just found out that he or she has a county court judgment as part of their credit check that they were doing. So, of course, if you are making amends towards it, then you can put in there that, yes, I have a county court judgment in terms of this and that. It's always good to disclose. So you disclose it, and then, of course, they can check and see that you are making amends. So if obviously there is an amount that needs to be paid off and you are making amends to pay it in installments, or you can pay it outright, then of course do so rather than just leaving it as it is. So of course disclose it, and once you've disclosed it as well, if it's something that is in isolation, like I said, they may not necessarily refuse the application. They will look at the fact that maybe it's a one-off and you are making amends to clear it. And so, of course, if you have done what you need to do in terms of amending the situation, then it may not necessarily end up in you being refused, but it could end up in a refusal if you are not making any attempts to to make sure that it's cleared. Yeah.
Okay. All right. Anne is saying sometime last year I was caught over speeding and was given penalty points and requested to pay a fine. I have paid the fine and now want to know if it would affect my application for naturalization, which I'm about to complete.
Okay, so usually with fines are also known as convictions, unfortunately. So if you are fined, it would also come into record that, of course, you committed so and so offense, and therefore this is the penalty. Because it's a non-custodial offense, so it's not an offense where she was taken to prison. 3 years will have to pass from the time that she was given the fine for them to then consider her application for naturalization. And like I said, it's a discretion, so they may grant it if they think that it's an isolated incident which was committed maybe 2 years before she was making the application. But if it is something that she persistently does and is always receiving a fine, then of course, unfortunately, she will have to wait for 3 years to pass before she makes the application for naturalization, because they will definitely refuse. And usually, even if the 3 years has passed and you have shown complete disregard for the law, and they see that this is something that you often do, so maybe you are often caught over speeding and you are constantly being fined, or you are constantly being given penalty points, then they may view you as somebody who is just showing complete disregard for the law, and they may refuse even after the 3 years has gone past. But in Anne's case, if it's an isolated incident and maybe 2 years have passed and she's somebody who is generally somebody who is of good character, they may allow her to go with this one, and she could be granted naturalization as a result of her good character.
Okay. So if I heard you right, if you are in the process of trying to sort out any convictions or trying to sort out your like CCJs or any financial arrangement that you have with the lender, you have up to 3 years to sort it out, then apply.
So usually with most non-custodial sentences, so it's different from an offense where you have been sent to prison. So if you've been sent to prison for, let's say, a period of 6 months or 12 months, you will have to let 10 years pass from that time to be able to make the application for them to look favorably on your application. Whereas with non-custodial sentences where you have not been sentenced to a prison or anything of that sort, usually 3 years will have to have passed from the time that you were, should I say, given that penalty, for instance, a fine or whatever it is. There are certain penalty notices, like they would ask you, for instance, don't park in this area, and you were parked, and they will bring you a penalty notice. Usually that will not result in them refusing your application if you can show that you have tried to obviously deal with that penalty notice. Whereas things like fine and community orders, obviously, even though they are non-custodial sentences, they are sort of a dent in your criminal records. So they will naturally say that there has to be time that has to be passed, and usually that's 3 years for them to be able to look favorably on your application for naturalization.
Alice just sent me a quick question. It's very interesting. He's saying that if you see, sometimes if you have some CCJs or you owe a financial institution and it's on your credit file, it takes a number of years for them to take it off, even though you weren't able to, pay them off. It takes a number of years, and that is just taken off your file. He's asking, when that happens, will you still be penalized? Because meaning you weren't able to pay off that money or clear that CCJ.
Okay, so usually with the civil court orders, they do not necessarily refuse it unless the person is saying that they are not making any attempts whatsoever to have it paid off. So in civil court matters, is sort of a bit different to even NHS debts. So with those ones, the stance of the Home Office is that we may not necessarily refuse the application unless the person is saying they are not making any attempts whatsoever to go by the order. So if you know, for instance, that you have a county court order against you and you are not making any attempts to rectify that order, then of course, then they may refuse your application. But in instances like that, even if it's going to take you 5 years, 10 years for you to clear it off, there isn't the presumption that your application should be refused. It is normally the fact that the person may not make any amends in terms of that order, that county court order that has been given to them. So if that person is actually trying to pay off those debts, then of course they can still make an application for naturalization.
Okay, so even though that has been written off, you still have to make contact and sort it out.
Yes. So if, for instance,
okay,
the county court order you said you didn't know about, so there's different if you knew about it and you've made amends, and then it's different if you didn't know about it and so you're now finding out. So if you're now finding out, then of course you need to make sure that you've made contact to try and rectify that. Yeah.
Okay. All right. Brilliant. Yes, I've got another question here. I think this. Just bear with me. Okay, I can't get the name clearly, so I'll just read it without mentioning the name. It was discovered during my application for indefinite leave to remain that I previously allowed someone to take the ESOL test and live in the UK test for me when I applied for leave to remain. I eventually took both tests on my own and passed before I applied for the ILR. I was then granted ILR. Can I still apply for British citizenship?
It's a long time since I heard about people taking tests for them. But
yes,
I mean, these things do happen. And like I said, one of the requirements for meeting those naturalization requirements is to be able to show that you've done the English language test and that you